Good evening, everybody. Hello, hello. Mic check. 1, 2, 1. Hopefully, audio. How's everybody doing? Thank you for being here. I'll let some notifications click in. Kane B, hello. Kane says hop in later. Thanks for being here. Meg P, hello. Yeah, don't forget to leave your mark on your right. Sorry, guys. If I sound a little, because I'm still not feeling good. Yeah, no, I feel the same. Something's wrong here. Karma Police, hello. How are you? Always good to see you. Thanks for popping in. All right. Hello. How are you? All right. So I'll give it a few minutes. I'll let these notifications. Oh, you know what? I forgot to hang on. Hang on. Let me get over here and do it from my phone. Now, actually, thinking about it. Let me go fix my chat here. That way I don't end up with comments going absolutely insane. Let's see here. Right. Put that on. We're going to put on. We're going to. Yeah. All right. There we go. Hopefully that helps the mods too. I just slipped to 45 seconds, but he was bitching about it being at 60. All right. You guys wait 40 seconds, okay, before you could slam another comment in the chat. Fuck. Hang on, Meg. Maybe if does that any better, honey, with the audio? Turn it down a little. Let me know if that's any better. Tom Campbell, hello. How are you? Carla, hello. Sound's cutting in and out. Is my sound still cutting out now? So is my audio still bad or what? One's in the chat if the audio is better. Two's if it sucks. Need some Z's. Hi, honey. How are you? Welcome on in. Hi, Anna D. Hello, Vonda. Hello, Vonda. Vonda. Yeah, I mean, I don't know. I hope my audio does okay. A little bit. Keep yapping so we can see. Yeah, kind of. Okay, hang on. Fucking fuck, hang on. What about that? Wonder if that helped the audio at all. Dagburn, how you doing? Welcome on in. Stacy Martell, hello. How are you? Steve W, hello. Mark B, if I didn't get you, hello. My sound is a bit muffled. There, I sounded good. Well, you know, at this point. Mercy Cat, hello, honey. How are you? So good to see you. I know you had a really long week last week, darling. Well, this week. I know you've been very busy. Hopefully you get to take a rest. Thanks for popping in. Really appreciate you. Love you, Mercy Cat. Don't forget, everybody, give some hearts in the chat for your mods because they're amazing. So, all right. So, yeah, fork and hold on, everyone. That's right, It wouldn't be alive if I wasn't having audio problems, though. I mean, it's just kind of the norm around here. Quality Emerald, hello. Eddie, darling, hello. How are you? You're on your phone, but you made it. Well, thank you for being here. No worries if you can't answer and you just want to lurk and listen. Not a problem, friend. I know you like to let me know when my audio is bad, though, so appreciate you. Hope you're doing well, Eddie. Hi, Patricia. Hello. Phil Biggs, always good to see you. Appreciate you being here. Batsheet, hello. Cat K, hello. All right. So, I know when we were the other night going through everything, I was looking at that document and I was like, oh my God, it's 30 pages. We'll save it for today, right? So that's what we're doing. Saved it for today. Some good nuggets in here, though. Some good nuggets in this one. Not gonna lie. Although, your girl here is pretty dumb. And maybe it's because I wasn't paying attention to my own chat because I was in another window looking at the damn text message transcript or whatever. So I wasn't even looking at my chat. I'm looking at the 911 call transcript. My dumbass. It's like, wait a minute. How many men? How many women? Not realizing that a couple of these men that are they're talking about here, Q1 or whatever, Q2, they're officers responding, right? So, my bad. I probably should have paid attention to my chat. I think what I need to do is probably go figure out the list, right? That might help. And then just put the names or whatever next to their little list they got there. Because I was looking at it and I'm like, what? But that's okay. It is what it is. Shit happens. I was looking at it like, wait a minute, who's who? What? Where did I put it? Okay, that's there. This one's here. That's the one I wanted. All right, so I wanted to do this real quick. Where? This thing right here. All right, we're going to go with chat. I'm going to bring it up in the screen and we're going to do this together because your girl is, this one. Danger. How you doing, Danger? All right. So you guys can see this, right? Q is dispatch. Q1 is a man. Which man? Is that a damn cop? Who is it? I'm going to rely on chat here, right? I'm just going to type it right in. Who's who here? Yeah, they are a little bit confusing, right? Because I'm looking at it like Q1's a man, Q3's a man, Q4's a man. JB, how you doing? So we'll do this together, right? Why not? Since, 911 call is an act. Well, kind of agree with you there, Eddie. But for funsies and for shits and giggles, what we're going to do here is let's try and decipher this little list because what I want to do is type it in right next to it so that when my dumbass is looking at this document, I know who is saying what to who. Know what I mean? Might make it'll help me a little. That's all. Yeah, dispatcher was asking the first responders. Right. That's what it sounds like. I kind of figured that out, that towards the end of the call, the defibrillator thing, someone's already arrived and she's asking them if they have a defibrillator. Makes sense. Right. Totally get that. But what I'm trying to figure out, we have, so Q1 man, right? Lorray, how you doing? Lorray. Hello, Twiz. Hello. Twiz, darling. How are you? Thanks for popping in. All the Qs will be first responders. Thank you. Thank you, Mandy. Appreciate that very much. Dreamer, hello. Okay, so all your Qs. So Q2, woman 1 is an officer. I don't know about that. Is it? I'm good, Twiz. Just trying to, because for me, for my brain. Um, so is Q2 like a female, the female dispatcher? I thought Q dispatch is the Calvin lady, right? So there's another woman for dispatch, or was that an officer, a female officer? Hmm. Whatever. Guess it doesn't matter. It's just for me in my own brain when I'm reading through something. Um, Echoes, how are you? Thanks for being here. Either way, So, anyways, let's see. That's why I'm asking, right? Q1, 70 is en route. Q2, copy. Q1, copy, right? So after Q2 says, I copy, dispatch comes back and says, unintelligible, 58. Multiple RPs on the phone. Advise saying the roommate on scene is passed out and not waking up. Believes she got drunk last night and, unintelligible, about a male being in the room with them. Q1 pops in, being around. Q comes back. That one I copy, about 20-year-old female, unconscious, trying to get further. I made a little note here because up until this point in this conversation, no one has said the age of the unconscious female. So I'm super confused as to how this one that says dispatch, right? There's two. Is this like, I don't understand what's happening here. Is this the same dispatch person saying copy, 20-year-old female unconscious trying to get further, right? But no one says she's 20 until down here, until after. And this is after A2, Evan. She's 20. Right? But I'm super confused as to how anyone knew prior to Evan here saying her age. Dispatch already knows it's a 20-year-old female who's unconscious. Is this making sense to anyone? Q1 is responding fire station. Number is 1070. Okay. But no one has said anything about a 20-year-old. So how are they communicating with each other about this 20-year-old? No one has said anything about her age. Bunny Murphy, how you doing? You only see a black screen, need some Z's? What? You guys only see a black screen? It looks like you can see the screen on my end. It says I'm sharing. Somebody let me know in my chat if you can see the damn screen. What the hell is happening? It looks like it's sharing on my end. I mean, I don't, yeah, well, obviously, Meg, right? Redacted. I get it. Totally get it. So I think the same thing. James Moen, you're definitely not timed out. I can see you. Just getting back over to hi to everybody. So, can you guys see the screen or no? Because everything look okay. You can see it. Okay, cool. Okay, well then I don't know why somebody else is only seeing a black screen. Okay, cool. Just making sure. Thanks, friends. Okay, so getting back to this, right? Go back over here. I'm in another window reading, so I cannot see chat. Now, I just wanted to kind of look at this again, right? Because it's interesting to me that I don't know what's going on here, but it's very interesting to me that whatever's happening with this dispatch, before anyone tells anyone about the age of the unconscious person, they're already talking to each other about it being a 20-year-old when no one says her age until Evan. It's very weird. Moonlight. And, I'm not even trying to, conspiracy theory or nothing. I'm literally just looking at their damn transcript. And I'm trying to figure out how dispatch people already know this is a 20-year-old before anyone says the age. How do they know that? Young Black Economist, welcome on in, darling. Good to see you. All good now, need some Z's? Good, you figured it out? I'm like, okay, I don't think it's us. I think it's you. Evan, I don't know. Twiz pointed out last night, it could be that, like, someone's saying, yeah, it's Ethan, right? And maybe it was just transcribed wrong. But wasn't, what was the neighbor guy's name? Wasn't his name Evan? Wasn't it said in the beginning, the neighbor across the street? Wasn't his name Evan? I don't remember. But whoever this person is, they're saying, yeah, it's Evan. That's how it's transcribed anyway. So, I mean, I don't know. Yeah, that's what it seems like, Eddie, right? They already knew of the situation. Because even when you're looking at this, the first thing they want to do is just like, can we just tell you what happened? Can I just tell you what happened pretty much? So at 4 a.m. Know what I mean? So it's just really interesting. Something's happening. Something happened in our house. So what? We have. So it's not 911 location, right? Hi, something's happening. Something happened. House. It's got to be someone who lived there. This is either Dylan or Bethany. This has to be one of them in our house. We don't know what. Right? I mean, you could go through it line by line, and it's just Jeremy. Oh, thank you. Okay, that was his name. Jeremy. My bad. No, I always felt like there's a damn Evan in there somewhere where I heard the name. Anyways, yeah. Well, here's the other thing about this 911 call, right? Even when they finally get the address out, what's the phone number? right? Here. One of the roommates passed out. She was drunk last night. She's not waking up. Someone in the background, no, we saw, right? And then the person who's saying, oh, she was drunk last night, not waking up, says, oh, yeah, and they saw a man in their house last night. Yeah. Female says, hi, are you with the patient? I need someone to keep the phone. Stop passing it around. Can I just tell you what happened pretty much? What is going on currently? Is someone passed out right now? I don't really know, but pretty much at 4 a.m., right? Need to know if someone's passed out. I need to know what's going on right now. If someone is passed out, can you find that out? Right? So here, she's not waking up. Unconscious, 1122 King Road, right? Nowhere in here. Even though she's getting the help, whoever this dispatch is, right? Okay, one moment, I'm getting help, started that way. At no point. She's not waking up. She's unconscious. No one is saying, have you started CPR? Do you know how to do CPR? Do any of you who are passing this phone around know how to do CPR? Has anyone administered CPR? So it's just kind of strange to me. Usually, you know, it's almost always they're kind of quick with the, okay, what? They're unconscious. They're not breathing. Do you know CPR? Is there anybody you can get to help you? It, and I'm not seeing like any conversation like that until the whole defibrillator thing comes into play, right? Way at the end. Patient is not conscious, not breathing, you know? So I even typed it in here. At no point does dispatch ask if anyone is CPR certified or knows CPR. Dispatch does not ask about vital signs, pulse, performing life-saving measures, etc. Conversation is happening. No one's talking about blood. No one's talking about just very interesting. Yeah, does anybody, yeah, are you with the patient? I know. Yeah, no CPR comment, blood. I know. It's really weird. And, I just wanted to point it out. I went and looked back at it, and I, I don't know. I don't know how Q2 are able to copy with each other about a 20-year-old who's unconscious when at no point has the age been mentioned at all prior to Evan here. Okay. So that's just my opinion. I think this is strange. I'm allowed to have that opinion. Maybe it's nothing. Maybe it's something. I don't understand how they know it's a 20-year-old when no one has said the age of the person who's unconscious and not breathing. Right? So that's just my opinion. I'll stop sharing that. Let me get back over here. We're going to get to the one I wanted to do, but yes, I saw that, David. Yeah. She hired that lady a while ago. I think it's Barbara Wolf, if I remember correctly. She's like a 5th District, Florida head coroner, head ME, something like that, if I remember correctly. And yeah, deals a lot with like crime scene reconstruction and stuff. Okay, let me go find this. That was the 911 call. Let me go see which one it is. Sorry, I have too many tabs open. Text. Okay. There. Oh. Wrong one. It's not that one. It is... that one. All right. Let's get over here. There we go. I'm sorry. So very sorry. All right. Just wanted to kind of go back over this real quick. The text messaging between Dylan. I know we went over it last night. I did a cursory going over it. Kent Kearney, how are you? Welcome on in. Who else am I missing? Mita, how are you? I'm looking for the comment, but I don't see it. There you are. How you doing? Welcome on in. Hey, it says there's 106 people watching. So either give it a thumbs up, give it a thumbs down, follow your heart, do something. Okay. I haven't seen Eddie warn me about audio yet, so that is a good thing. I feel like he would let me know. All right, so I wanted to bring this back up because even after we went over it last night, well, you guys know me. I said, well, I'm going to go look at it again. And, let's just walk through this again. Okay. So these are the text messages between Dylan and Bethany. All right. Oh, James, I'm sorry to hear that. Jesus. Ugh, that's crazy. Sorry to hear that. It's terrible. Okay. True Crime Unraveled. How you doing? Welcome on in. All right. Let's get over here. So, when we're looking at times here, right? Now, obviously, I'm well aware we have lots that's missing. I already know that. We are not getting the full context of the text messages. I am aware of that. This is all that we can go by for now. I am aware many people think the 911 call is fabricated, the text messages are fabricated. It's just these girls covering their own ass for whatever happened in the house. I get that. But for the purposes of being equal on both sides here, right? Because we do cover a lot of defense documents, and we have to take it at face value from the defense, just like we have to take it at face value from the state, if we're going to be fair. Yeah? Everybody cool with that? So I understand that everybody already has all their own opinions about what this is, what it isn't, etc. But for the purposes of the fact that this is going to be a trial, this is what's going to be attempted to be used against Brian Kohberger. And, if it was a defense document, we would be taking it with the same weight, right? So That's just how I want to look at it. That if we were to, say, just forget this came from the state, if this had come from the defense, right? We'd all be losing our shit just as much as we are that it is from the state. But you get my point, right? Taking it with the same weight is kind of where I'm going out with this. Okay, cool. All right, cool. Danger's cool with it. Meg's cool with it. Then I'm cool with it. You know what I mean? So, if this is all this is exactly what happened as it happened. Okay? We'll just go along with it. So, at 2:10:29 a.m., Dylan Mortensen is sending a text message. A text message. Sends a singular text message to EG to inquire if he's driving. This is we all know, private driver of Maddie and Kaylee, and she is texting him a singular text approximately 12 minutes after Kaylee and Maddie are dropped off. And it just so happens to be that approximately 16 minutes after Dylan is texting the private driver, Kaylee starts cold calling and texting Jack for approximately 30 minutes, correct? I think it was approximately 30 minutes, the text messaging and the calls went on, not only from Kaylee's phone, but there was some from Maddie's as well. Seashells, hello, welcome on in. Heather Mosher, how are you? Welcome, welcome. Good to see you. No, that's not when it was downloaded, Heather, I don't think. That's when it was discovered. It's when it was turned over to the defense, right? Thought that's what it said. If I remember correctly, the language in the document is that the phone was discovered in April of 2023 to the defense. That's when it was turned over. I could be wrong, but I definitely feel like that's what they were saying. That's when it was discovered. April 2023, meaning turned over in discovery. Right? Or is colder covered? Where's one of my little fucking lawyer pals up in here? Little paralegals. Where are you at? I could have sworn that the text messages were discovered. Not discovered as in we just found them. There were forensic downloads of BF and DM's phones day of. There were forensic downloads of all of the phones day of. Specifically Dylan and Bethany's because they were the two survivors. Theirs were done first. So I think when they're saying discovered, the text messages were discovered in April of 2023, meaning discovery. It's when they were turned over in discovery. I could be wrong, but that's what I gathered from it. That's not when the text messages were discovered. It means discoverable to the defense. That was my impression of it. I could be wrong, but so ADH Stacy, how you doing? Didn't even see you. Maybe I did. Did I already say hi to you? Well, if I didn't, hello, welcome on in. Looking at my chat. Yeah, I think that might just be a misunderstanding there of the language in the document. When they're saying that these text messages were discovered in April of 2023, I'm almost positive they're meaning like discovered as in turned over in discovery. I don't think they mean that's when the cops actually discovered the text messages because the forensic downloads of the phones were done day one, especially for the survivors. So, anyways, let's get back over here. So, as I was saying, 2:10 in the morning, Dylan is texting the private driver of Maddie and Kaylee, who had just dropped them off 12 minutes prior. Within 16 minutes of Dylan here sending this singular text to this private driver, 12 minutes after he drops the girls off, Kaylee starts cold calling Jack, texting Jack, approximately 30 minutes. Then, so all it says is she's awake and texting at 2:10:29, and then it jumps to 4:19. So we have this 2-hour gap here. We don't know what's happening in this 2-hour gap with not only Kaylee, right? Because we know she's awake and she's texting. So Kaylee is awake and texting, blowing up Jack's phone as Dylan is sending a message to the private driver. Dylan is also awake and texting. There's a 2-hour gap. Starts up again 4:19 to 4:21. So for 2 minutes and 43 seconds, Dylan is calling everyone in the house except Ethan, and she is not getting a response, and that includes Bethany. She's calling everyone except Ethan. And then, approximately 1 minute later, after she attempts to call Bethany and Xana, Kaylee, Maddie, not Ethan, she has this series of text messages that goes on for 2 minutes and 19 seconds with Bethany. And then that's when she calls Ethan, right? Unanswered call. This is 12 seconds after she finishes the above text message exchange here. 12 seconds after she calls Ethan. Okay? After she calls Ethan, Dylan and Bethany continue to text. And 19 seconds after calling Ethan, Dylan texts Bethany, "I'm screwed though." Could be, "I'm scared though." And BF responds, "Yeah, I know, but it's better than being alone," which is why I think she meant to type, "I'm scared." That's just my opinion. Makes sense that Bethany would be responding, "Yeah, I know, but it's better than being alone." Like, doesn't matter if you're scared. Fucking run, bitch, right? Something's happening in the house. People are, whatever's happening, run. It's better than being alone. We have to take it at face value for what it is. I understand everybody thinks it's just all fabricated and fake. I get it. But this is what's going to be presented at trial against Brian Kohberger. So it doesn't matter if we think it's fake, fabricated, whatever. This is literally what they're going to put in front of a jury to try to convict him. So it's going to come down to seconds. It's going to come down to, does it match up? It's going to come down to how many steps are the phones taking when all these text messages are happening. Are people moving around the house? Are people going up and down stairs? Are they running? Are they walking? What is happening? Right? So it doesn't necessarily matter what we think as far as whether or not this is fabricated, made up, whatever. It doesn't even matter if that's what we think. It doesn't matter. This is what they're going to put in front of a jury. And it's going to come down to literally step by step, second by second. So, if she's meaning to say, "I'm scared though," it would make sense that Bethany is responding saying, "Yeah, I know, but it's better than being alone." This is where we're going to get into my little notes on the side here because these are just my opinions, right? So 19 seconds after calling Ethan, she texts Bethany saying, "I'm screwed though," or "I'm scared though." And BF responds, right? "Yeah, I know, but it's better than being alone." This is within seconds, literal seconds. 18 seconds later, Bethany is responding. I know, but it's better than being alone. Then, 2 minutes and 31 seconds after Bethany responds, Dylan calls Kaylee. The call goes unanswered. 57 seconds after calling Kaylee, Dylan calls Xana. Call unanswered. Now, I'm going to stop right here because it's interesting to me that whatever Dylan and Bethany are talking about up there, whatever they thought, Xana's in all black and a ski mask and etc., notice Dylan is only calling Kaylee and Xana. She's only calling Kaylee and Xana. It's interesting. And then 4 minutes and 13 seconds after calling Kaylee and Xana, she texts Kaylee, please answer. So I'm of the opinion the reason that she is calling these two girls specifically at this moment is because she either saw or heard something happening with these two individuals. And that is why she is calling the both of them. That's just my opinion, but it's interesting. She's only calling these two. Because it's almost like, right? She allegedly wasn't sure if what she saw was a dream. She thought it was all a dream. She's not sure what's real, what's not. It sounds like she literally thought like what she was hearing going on between Kaylee and Xana here, whatever's happening, like it's not real. There's no way. There's no way I just saw what I saw. There's no way that I just heard what I heard. And she tries to call both of them, and neither of them answer. And this is after her and Bethany are exchanging text messages about Xana was wearing all black. I'm freaking out right now. No, it's like a ski mask almost. This is what Dylan is saying to Bethany. And it's Bethany telling Dylan Xana was wearing all black. Dylan to Bethany. No, it's like a ski mask almost. Right? Bethany, shut the fuck up. Bethany, actually? And then Dylan, like he had some tibinf over his forehead and little and mouth. I don't know if she meant to put like she had something over her forehead and mouth. But the context of this conversation is Xana. And even though I know it says like he had something, I really think she is trying to say like she had something over her forehead and mouth. That's just my opinion. And then she says, Bethany, I'm not kidding. I'm so freaked out right now. So, you know, when we get down here and this is, let's see. Let's look at this timestamp real quick. 422 to 424. And then 427 and 428. So we're talking just 2 minutes and 31 seconds after Bethany responds, right? She calls Kaylee. 2 minutes and 31 seconds after Bethany responds. But when you look at the difference in time here, we have this text message exchange ending at 4:24:27. At 4:27:47, 3 minutes later, she's calling Kaylee and then immediately calls Xana. Only these two. And the text that she sends, this is 4 minutes and 13 seconds after calling Kaylee and Xana. She sends a text to Kaylee, please answer. Okay. Part of me is thinking this she is seeing something going on between these two. and she's not sure of what she saw, or maybe can't believe what she saw, and she's like, please answer, right? I'm under the impression here she is like, something's happening with these two specifically, Kaylee and Xana. That's just my opinion. Now the next morning, she sends the following text messages starting at 10:23, only to Kaylee and Maddie. So the last message to Kaylee is please answer at 4:32 and 57 seconds. And when she wakes up at 10:23:23, well, she's texting Kaylee, please answer. She's texting Maddie, are you up? Texting Kaylee again, are you up? She's not texting Xana or Ethan or Bethany. She's not texting any of the other people in the house. Isn't that interesting? So if she's calling them, because she thinks something happened with the two of them, and she's like, oh my God, did I really see that? Let me call, like, I don't know. I'm just, like I said, we're rolling with what's here because this is what's going to court. This is what's going to be said in court. So, for whatever reason, she knows the next morning at 10:23 when she's sending these text messages, well, there's no reason to text Xana or Ethan, or if she did, we just didn't get it. State didn't include it, right? I feel like they would have. They're saying she called Kernodle, she texted Kernodle, she called Ethan, she texted Ethan, right? So I feel like why not include it? For some reason, nope. 10:23 a.m. Dylan is only texting Kaylee and she's only texting Maddie. She's not texting. Also, interestingly enough, when Dylan and Bethany do summon people over, and those people, Hunter Johnson directs them to call 911. Do you notice that, like, it would appear no one bothered to even go tell Kaylee and Maddie, hey, we're calling the cops? There's no talk of anybody else in the house whatsoever. Any other roommates. It doesn't even appear that Dylan or Bethany here, other than a text, please get up, are you up, even attempted to go upstairs to let the girls know, we got to call the cops. Xana's fucking dead down here. Okay? Not trying to be, gory or anything. I'm just speaking real, right? I'm being real. I'm just being real here. It makes no sense to me that Dylan and Bethany both know they apparently don't need to go get Kaylee and Maddie or alert them to Xana being unconscious downstairs. For fuck's sake, Fitziana, good evening, darling. How are you? Welcome on in. So good to see you. Musical Contessa, how are you? Thank you for being here. So I hope you guys get what I'm saying. Let me come and check my comments. I don't know, maybe Carla, I'm not sure. I'm not sure exactly what they're getting at here. But it's very, very interesting to me that when you look at the context between Dylan and Bethany and then rolling right into this, right? It's very interesting. Because we're talking, these are like, some of these are seconds, 12 seconds, 10 seconds, apart. So don't you think it's pretty interesting here that for whatever reason, Dylan knows by 10:23 a.m. First of all, she knows at 4:27 a.m. Okay? That I'm just going to call Kaylee and Xana to see, like, was that real? Did I really see what I thought I saw? And they're not answering. So she texts Kaylee, please answer, right? And then nothing for like 6 hours. And the only people she's texting at 10:23 in the morning is Kaylee and Maddie. And she's not texting Ethan or Xana. But by the time Dylan has her text messages with her dad, she calls EA or texts EA and gets some texts from Jay. No one has attempted to go alert Kaylee and Maddie upstairs that Xana is downstairs, passed out. Isn't that odd? It would appear that they did not even attempt to alert Kaylee and Maddie to what was going on downstairs. I mean, it's my opinion. The reason she isn't going to, like, gotta go upstairs to see what's going on is because whatever happened between this 427, okay, when she's calling Kaylee and she's calling Xana or sending text messages, there's something happening here between this 422 to 424 timeline where Dylan and Bethany, for whatever reason, believe something is going on in this house involving Xana and likely Kaylee. What that means, I don't know. But that's how the selection of these text messages make it appear. So whether the state meant to do this on purpose, I have no idea, but the selection of it. It's interesting, right? So 1 hour and 16 minutes after texting only Kaylee and Maddie, she has this text exchange with her father. So there's an hour and 16 minutes that goes by from her texting Kaylee and Maddie, are you up? Please answer. We have another hour and 16 minutes that goes by. And then approximately 11 minutes after texting her dad, she receives a text from Jay stating, bro. 3 seconds later, she gets another text. 3 seconds after the text from this Jay saying, bro, she calls EA. She gets another text message from this Jay person with no context that we don't have here. 3 seconds after Jay texts bro the first time, he texts again. So we get 2 texts in a row, 3 seconds apart from Jay. And it's very interesting. We have an hour and 15-minute gap here from texting Kaylee and Maddie saying, are you up? Please answer, to these, text messages rolling in. It's wild. Before she's texting her dad, we have an hour and 16 minutes that goes by. Yeah. Well, that's what I mean, Heather. I don't know, Heather Mosher. I couldn't tell you. It's just very interesting when you think about it. When you kind of just go like line by line and you realize that like we're talking seconds apart, some of these literal seconds. Then we have, is she's waiting an hour and 16 minutes after texting them. We have this hour and 16-minute gap. But I don't know. I'm looking at it and I'm of the very strong opinion that right now, based on what we're looking at, whatever she thought she saw occurring at this time, her and Bethany, they believe it's involving Xana. And I don't know why that is. I don't know why they're talking about Xana being in all black. And no, Xana was wearing all black. No, it's like a ski mask almost. I'm freaking out right now. Well, I mean, what are you freaking out about? And if you are both freaking out and you're both like, what the fuck, run to my room, you know what I mean? Hurry up, hide, run. What is... What is happening upstairs? With Xana and someone else. It's very, very, very interesting. And we know that there's other men's blood in the crime scene, correct? I feel like we read in one of these documents that when the back of the sheath was swabbed, blood was found, blood was detected, mixed sample, right? Not Brian's. So, I don't know. It's very interesting to me. Christina Lily, how are you? Welcome on in. Yeah, I know. We don't have Bethany's text yet, but, would be nice to know. It's just interesting to me that these two girls at this time of the morning are telling each other, fucking Xana's running around wearing all black. No, it looks like a ski mask. They are not talking in any context about a fireman, about a perpetrator carrying a vacuum type object. They're not talking about men in general, scary men, a guy in here. Nothing. Nothing like that is being said. All of the context pertains to Xana. Claire Bear, how are you? Well, it would appear Dylan never even left the second floor because Bethany is telling her to run downstairs. Hurry, come to my room. Run down here. And, well, it would appear she didn't because they continued to text each other, right? So if Dylan and Bethany are continuing to text each other at 4:24:58, and this is after Bethany tells her, come to my room, run down here, right? Well, it would appear Dylan didn't go downstairs because she's still continuing to text Dylan and Bethany, which is, Bethany, which is why I think this text message at 4:24:58, where it says, I'm screwed though, part of me wonders if she's trying to type, I'm scared though. And that's why Bethany responds, well, yeah, I know, but it's better than being alone. I don't think Dylan did go downstairs. Doesn't appear she went downstairs because they're still texting each other. So clearly they're not in the same room with each other. But that's just my opinion, right? I don't see why two girls in the same room with each other would need to text each other. It's not unheard of, right? Kids will text each other even in the same damn room. These younger, they'll text each other even when they're in the same room just so they don't have to talk to each other. But I don't think that's what's occurring here. I think she didn't leave her room. If we just take this at face value, that this happened accurately as the way they say it did here, right? If we're going to take it at face value. So, the way I look at it is I don't think she went downstairs to her room. She stayed upstairs. And her and Bethany know there's a problem happening 4:22 to 4:24, and they know it's involving Xana in all black and a ski mask. And the context of this conversation is not pertaining to men, multiple men, scary men, burglars, firemen, none of it. None of it. Firemen carrying vacuum type objects, none of it. None of that is occurring in this conversation that we have here so far. Right? So, for whatever reason, the entirety of this 2 minutes and 19 seconds of this text exchange that we have here, for whatever reason, the two survivors think something is happening in this house and it's pertaining to Xana. So, that's interesting. Now, obviously, right, as I've said before, yeah, I understand. We all think, a lot of people think it's bullshit. It's fabricated. All they're doing is setting their alibi, blah, 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 blah. I mean, I guess it doesn't matter at this point what we think. All that matters is that this is going to go in a court, before a court, in front of a jury, and they're going to try and execute Brian Koberger with this. So it would probably be best of us to do our due diligence here and take it for what it is, because this is what's going to go. It's what they're going to use at trial. Justice, how you doing? David Bird, hello. Sorry, I'm coming back over to chat, guys. Becky, hello. Yeah, I mean, could be. Could be Becky. In the same room texting, don't want to talk out loud. I mean, yeah, you're right. Could be. But we don't have those texts. Well, that's what's interesting too. It would appear some of these texts, there's conversation missing. Obviously, we don't have the full scope of all of the texts. If we had the full scope of everybody's text, it's not going to be this short little thing here, right? We're not going to get like the full forensic download of Bethany and Dylan's phone. I don't think. They're just giving us the pertinent time frame here to fit their 4 a.m. time of the crime, between 4 and 4:25. That's why you're only getting text messages that are pertinent to that time, and then obviously a little bit after for the 911 call. Know what I mean? So, anyways, so yeah. Now, 10:23 a.m., she's only texting Kaylee, only texting Maddie. She's not even attempting Xana and Ethan anymore. That's the other thing. Xana and Ethan are never attempted to be texted or called again, according to this from the state. Detective Mowry, how you doing? Welcome on in. I don't know, Rochelle. So Dylan wakes up at 10:23, and for the rest of the morning, she just knows, like, well, I mean, I don't need to call Ethan. I don't need to call Xana. These two aren't answering, right? But let me just go ahead and text my dad real quick. And, it's an hour and 16 minutes after she sends text to Kaylee and Maddie. She has this text exchange with her dad. And then within 11 minutes of this text exchange with her father, she's getting a text message from this J person stating bro. And 3 seconds later, she's calling. So, I'm sorry. Yeah. So 11 minutes after the text exchange with her father, she's getting this text from this J person saying bro. And 3 seconds after the text from J, she's calling EA. And then another 3 seconds, she gets another text from J. So something tells me here, just my opinion, but I'm under the impression here her father is having this person J text her to find out what the fuck is going on. That's just my opinion. It's 11 minutes after she has the text exchange with her father. She's getting the text from Jay saying bro. I'm wondering if her dad is having someone contact her to find out what's going on. It's 3 seconds apart. Boom, boom, 2 texts. First one just says bro. Second one, we have no context. I don't know if she was calling her dad to cover her ass or she's calling her dad because she doesn't know what to do. I don't know. Right. Could be. Yeah, I don't know. But you think a lawyer's going to text her to say, bro? I don't know. Exactly, Rochelle. That's kind of what I was just saying a few minutes ago. Um, so worried about Kaylee, but then when they're calling to say the roommate's passed out, they're not even mentioning, by the way, we have other roommates upstairs who haven't been. It's not just the one down here who's unconscious. We can't get in touch with our other roommates either. It would appear nobody even went upstairs to get Kaylee and Maddie and let them know Xana is unconscious downstairs. It's like they knew they didn't need to go get. I'm sorry. It just sounds to me like they knew Kaylee and Maddie weren't going to be able to answer anyway. That's just my opinion. Um, it's just strange to me that they didn't. It's not even mentioned. The other two girls in the home aren't even mentioned. Neither is Ethan. It's weird. And, sadly, I don't know, I have no idea what the defense angle is going to be here, but I could tell you right now, looking at some of these text messages and what's happening and in the time span that they're happening in, and one of the victims is wearing all black and what looks like a ski mask. Sidebar, I will pass out, literally pass out. If, Noon's body cam on arrival, first responding officer who gets into the house and discovers her, the one who clicks in on the 911 call to say, yeah, we got a homicide here. This is not an unconscious person. Okay. Uh, that body cam, I will pass out if Santa is, quote, clad in black with a ski mask on, bro. I'll pass out. For fuck's sake, Fitziana, you and I will literally spontaneously combust and fly off into the night, into the moon. Okay? We're going to combust into 1,000 bats and fly off into the moon. If Body Can comes out and they arrive and Xana is, yes, unconscious, yes, deceased, but she is what would appear to be clad in all black in a ski mask. I will literally pass out. You know? Well, that's what I mean. If she wasn't wearing it when they found her, correct. But then that would also mean, well, then when did the clothes change? Right. When did the clothes change? Who changed the clothes? Did she change? There's something very strange happening in this house, and Bethany and Dylan both know it. They both know it. And they know it involves Xana. Uh, yeah, right. Wearing all black. I mean, it's just when you look at the whole, suspect was clad in black, mask. You have these girls talking about, and the whole thing is just, it's mind boggling. It's absolutely mind boggling when you really break it all down. Why weren't you concerned about making sure that you go get Kaylee and Maddie upstairs and let them know Xana's passed out down here? We got to call 911. You guys got to wake up. We got to call 911. There's no text messages or anything occurring to Kaylee and Maddie outside of the "Are you up? Please answer." Like, you need to get up. You have to wake up. Answer the phone. Xana's passed out. Xana's unconscious. We don't think she's breathing, right? Maybe those text messages do exist, and obviously just not included here. It could be. I'm just talking about what we have to go on right now. You know what I mean? Looking at just this file. I don't know. the whole thing is, I mean, I don't know, batshit. I don't know who was out of it, who wasn't out of it. Well, yeah. Yeah, I said that last night, Anna D. I mean, it was well known, actually. These kids played all kinds of... You found who, Twiz? I missed a comment. Hang on. Oh, yeah, Cy. Mm-hmm. He was on that swingers case. He was testifying for that swingers case. Trying to remember who was covering it. But yes, he did just provide testimony in that swingers murder case there. Cy. Twiz is talking about Cy Ray. But that's where he's been. He was doing work for that swingers case. Yeah, mushrooms will mess you up. Yes, at trial, yeah. Well, I think he's done testifying now. I could be wrong, but I think he already did his testimony. He did, yes, Twiz. Yeah. Mm-hmm. He sure did. Two guys, one sheath. Yeah. Two guys, one sheath, Detective Mallory. Mikey S., hello, welcome in. Good to see you. So anyways, you know, Alessandra. Hola, mi amiga. Have you been in here this whole time and I just didn't see you? Sorry, darling. Now, Twiz made me lose my train of thought because he said something about I found him. Damn it. Twiz. Go back and look at this. I don't remember what my train of thought was, but you know what? That's okay. Whatever. I'm going to stop sharing that because we have a 30-page document to get into, damn it. And yeah. All right. So, which one's this? Oh yeah, okay. I don't need that one open anymore. And we're just going to use that one. This one has some good little nuggets in it, though. Make that a little bigger. Ooh, that might be too big. How's that? Yeah, that should look good. Let me check. Make sure this looks good for you guys. How's my audio doing? Doing all right so far? No major hiccups, huh? Silent G, how you doing? Oh, well, welcome in, Mikey. Thanks for being here. All right, so this one here is going to be the defendant's motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. All right, everybody ready? We got 30 pages to go here, so pull up your sleeves, grab a drink, grab a snack, get a blanket, whatever you need to do. Comes now Brian C. Koberger by and through his attorneys of record and respectfully requests that this court remedy the state's failure to comply with its obligations under the state and federal constitutions, state law, the rules of the Supreme Court of Idaho, and the scheduling order of this court. The state has failed to provide expert disclosures that are specific enough to understand what testimony and discovery it intends to rely on, depriving Mr. Koberger of the ability to conduct independent review and investigation of the evidence it will rely on. Additionally, as counsel has previously stated, the discovery in this case has been provided in a manner that is as though the state took tens of thousands of documents, photos, and video clips and shook them up in a snow globe. While defense counsel has made Herculean efforts to review the discovery provided, there is no possible way that all of the discovery, which is the equivalent to 68,000 copies of the Encyclopedia Britannica, can be reviewed prior to the trial date. Indeed, a defense expert informed counsel it would require 3 additional years to review all of the discovery from the 67 electronic devices and digital data alone. Sidebar: 4 victims, 1 Koberger, 67 devices. Interesting. By providing discovery in this manner, the state is failing to comply with their obligations under Brady v. Maryland. Oh, would you look at that? It's the Brady bunch. Back at it again. These cases require the prosecution to provide exculpatory and impeaching information to the defense, including any information that would tend to mitigate the punishment, even if it is not constitutionally material, in a manner and time frame that it could be reasonably relied upon in preparing for a trial. As discussed in this motion, in cases with enormous amounts of electronic data, the prosecution does not meet that standard by providing discovery in a manner that effectively buries exculpatory, impeachment, and mitigation information. Timely and meaningful disclosure is indispensable to the effectuation of the right to a fair trial, due process, effective assistance of counsel, and the right to be free from cruel and unusual punishment pursuant to the 6th, 8th, and 14th Amendments to the United States Constitution and Section 6 and 13 of Article 1 of the Constitution of the State of Idaho. Little footnote here: a single Encyclopedia Britannica contains more than 30 volumes. Sure does. Mr. Koberger requests that the court exclude evidence and testimony that the state has not yet provided in adequate expert disclosures. An accompanying motion in limine has been filed regarding the specifics of this evidence. The details are not repeated herein, but incorporated by reference. Exclusion of that evidence, however, is insufficient to cure the whole of the prejudice to Mr. Koberger. Let's repeat that again. Exclusion of that evidence is insufficient to cure the whole of the prejudice to Mr. Koberger. Like other trial courts around the country, this court must also, 1, order the prosecution to provide a detailed index of documents it intends to rely on, as well as an index of Brady information. And 2, preclude the death penalty at the upcoming trial in order to meet the constitutional standards of due process and a fair trial. Mr. Koberger acknowledges this motion requests preclusion of the death penalty as one of the remedies after this court's order deadline. Wait a minute. Mr. Koberger acknowledges this motion requests preclusion of the death penalty as one of the remedies after the court's order deadline. Gotcha. Sorry. Took my brain a second. However, good cause exists for the filing. The state has produced an enormous amount of disorganized data, continues to provide discovery past their deadline, refuses to provide requested supplemental discovery, and has failed to abide by expert disclosure rule and order. Footnote 2 for supplemental discovery, right here. Mr. Koberger has litigated the state's identification of him through its IGG investigation. Multiple discovery requests, motions to compel have been heard. During his motion to suppress, Mr. Koberger learned new information relating to procedures and protocol, laboratory information about its work, and additional investigation that took place. He promptly requested the same through discovery. His request resulted in the state acknowledging it withheld information sought and a refusal to provide it. The state further promised some discovery, which has not yet arrived, but overall said Mr. Koberger was too late to get the information. Mr. Koberger has filed a motion in limine to exclude IGG. Those arguments are incorporated but not repeated herein. Okay. Relevant factual background. Mr. Koberger has consistently demanded that the prosecution comply with its obligations under the state and federal constitutions to provide exculpatory and impeaching information to the defense, as well as any information that would tend to mitigate the punishment. The defense has filed more than 20 supplemental requests for discovery, specifying evidence the state has failed to turn over. The state turned over more than 68 terabytes of data. That much data is the equivalent of 68,000 copies of the Encyclopedia Britannica. And then it gives you all these citations here for where you can find, how many pages for each thing. 400 gigabyte laptop hard drive can store over 200 million pages, blah, blah, blah. It gives you all the citations. The discovery that has been provided includes more than 13,000 photographs, more than 15,000 video clips from businesses, more than 8,000 video clips from residences. It also includes more than 60 plus digital devices and digital data and search warrant data, including cell phones and laptops from Mr. Koberger, the victims, alternate suspects, and various other individuals who knew the victims. Hold, please. All right, sorry about that. Sorry about that, friends. I'm back. Yes, hello, hello. Sorry. I had to say hold, please. Sorry. Okay, so let's read this again. The discovery that has been provided includes more than 13,000 photographs, 15,000 video clips from businesses, and 8,000 video clips from residences. It includes more than 60 digital devices and digital data, search warrant data, including cell phones and laptops, from Mr. Koberger, the victims, alternate suspects, and various other individuals who knew the victims. Interesting. So they have all the digital data for not only Mr. Koberger, but the victims, the alternative suspects, and various other individuals. Interesting. What do y'all think about that, huh? Yeah. Second State Films, exactly. Kane B, hello, welcome in. Did you just get here? Hi, Kane. Good to see you. All right. So, all the digital data for not only Koberger, but the victims and the alternate suspects. Awesome. While the state has had access to many dozens or even hundreds of detectives and investigators from multiple law enforcement agencies, including the FBI, in addition to the use of expensive AI and technological programs to facilitate production and review of this massive amount of discovery, the defense team consists of 3 attorneys, a mitigation specialist, and 3 investigators. There is no way, even through the greatest of due diligence, that the defense can independently review all of the discovery. I mean, in providing discovery, the state has not provided it in a searchable format, has not provided detailed logs and indexes that would facilitate the defense's review of the evidence, and has not provided an index of Brady evidence or evidence that may be relevant to the defense. Additionally, the court set an expert disclosure deadline that passed more than 1 month ago. While the defense complied, the state provided vague disclosures that failed to identify opinions that experts would provide or detail the facts and evidence they would rely on for those opinions. For example, the state's expert disclosure listed 3 alleged experts who would testify relating to the 67 electronic devices, digital data, and search warrant return data as provided in discovery. The scope of that evidence is so broad that a defense expert estimated it would take more than 3 years to review. The state did not identify any actual opinions it intends to elicit about these devices and failed to identify any portions of the data that would be presented or relied upon. Oh boy. Well after the disclosure deadline, the state turned over a report stating that examination of the devices are still ongoing, which only heightens the prejudice to Mr. Koberger and further depletes his time to conduct any independent review or evaluation of the state's evidence. How are you still doing examination of the devices? How is examination of the devices still ongoing when you were literally talking about it's wild to me. This is wild. We turned it up. We gave it all to you. We don't have nothing. To the extent that it isn't there, we don't have it. This is only one of the many disclosures in which the state failed to identify what opinion the expert would be testifying to and failed to point to the specific evidence or discovery that would be relied upon. Moreover, even after this court told the state that its job was not done with expert disclosures, the state produced a circular argument blaming the defense in its rebuttal disclosures about the electronics, digital data, and third-party warrants. No additional opinions, clarifications, or specifics were provided. And finally, Mr. Koberger requested additional discovery related to IgG after he learned of its existence for the first time in his motion to suppress. The state acknowledged it had undisclosed information, but refused in part to provide it, and promised in part to provide some information. No discovery has been disclosed. No discovery has been disclosed. For that anyway, or whatever. The part the state said they'd give, well, they didn't. The state has gained a tactical advantage that cannot be remedied now, and therefore this court must take affirmative steps to put Mr. Koberger back on equal ground. Mitigating punishment. Oh, wait. Oopsie. There's a period there. Haha, sorry. The state has gained a tactical advantage that cannot be remedied now, and therefore this court must take affirmative steps to put Mr. Koberger back on equal ground. Okay. Argument. Prosecution's discovery obligations under the federal and Idaho constitutions and Idaho law. Both the federal and Idaho constitutions, as well as Idaho law, require that the prosecution turn over any materials to the defense which may help the accused either by negating the guilt, mitigating the punishment, or impeaching the state's witnesses. See Brady v. Maryland. And then it goes here, due process, 14th Amendment. It cites all of these different cases, okay? Criminal defendants are entitled to proceedings that comport with prevailing notions of fundamental fairness. Another one here, accordingly, state violates defendants' due process rights whenever the state suppresses evidence that is material, either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. Prosecutors' duty to produce this material is self-executing. They must turn over Brady material, regardless of whether the defense has made a specific request. Good faith or bad faith of the prosecutor is not relevant to the Brady inquiry. See Giglio v. United States. Whether the non-disclosure was a result of negligence or design, it is the responsibility of the prosecutor. The prosecutor's office is an entity, and as such, it is the spokesman for the government. The duty exists even if the defense conceivably might have access to the information independently. So no matter what, even if the defense could go get it all themselves, doesn't matter. You still have a duty to disclose it all as the prosecutor, and you don't disclose it as though it's all in a snow globe. It's 68,000 copies of the Encyclopedia Britannica in a snow globe. It's not how you turn over discovery. Anybody trying to tell you that that's normal for discovery to be turned over that way, they're lying. It isn't normal. It's absolutely not normal. No, it's not. Non-disclosure of government witness, paid informant status, not absolved, even if the defendant might have uncovered it through independent sources. Tapes, like tapes disclosed to co-defendant, not effectively disclosed to defendant because trial strategies of co-defendant often conflict. That's United States v. Schaefer, right? Yeah, non-disclosure of government witness, paid informant status, not absolved, even if the defendant might have uncovered it through independent sources. B, the state suppresses exculpatory evidence when it does not timely disclose the evidence. Oh, interesting. To comply with their constitutional obligations, the state must disclose exculpatory evidence in time for its effective use at trial. Assessing materiality based on the impact of effective use of the exculpatory evidence. And then United States v. COPPA. With respect to when the prosecution must make a disclosure required by Brady, the law also appears to be settled. Brady material must be disclosed in time for its effective use at trial or at a plea proceeding. Emphasis in the original. Internal citation. Okay. When the state fails to produce exculpatory evidence in time for its use at trial, the state has suppressed the evidence in violation of a defendant's due process rights. Finding that the government suppressed exculpatory evidence by failing to timely produce statement of prosecution witness that differed from trial testimony. That's another case it's citing there. Additionally, when exculpatory materials have been disclosed too late for their effective use at trial, the untimely disclosure implicates a defendant's constitutional right to the effective assistance of counsel under the Sixth Amendment to the United States Constitution and Article 1, Section 13 of the Idaho Constitution. The right to timely disclosure of favorable evidence guarantees an accused sufficient time to investigate and evaluate the evidence in preparation for trial. In addition to allowing for full investigation, which could lead to more favorable or exonerating evidence, the timely disclosure of Brady material can alert defendants to viable pretrial challenges, such as suppression of evidence. And then United States v. Gamez or Duno, holding that Brady was violated in the pretrial context by suppression of a report that would have demonstrated Fourth Amendment standing to challenge a search. Okay. And then it has Idaho rules, professional rules of conduct, American Bar Association rules of professional conduct, and Brady progeny all require timely disclosure of discovery materials, meaning prosecutors must turn over information at the earliest feasible opportunity. Mitigating evidence is material when it may well have been consequential to a jury's deliberations on punishment. In death penalty cases, Brady includes information that may not exculpate, but that nonetheless mitigates. As such, even when evidence is not probative at all regarding a defendant's guilt or innocence, or even when the evidence is more likely to support a finding of guilt during the first phase of a capital trial, the evidence may still be Brady material if it could lead to lesser punishment. As the Supreme Court emphasized, while evidence that is material to guilt will often be material for sentencing purposes as well, the converse is not always true. As such, when the state has elected to seek the death penalty, the Supreme Court has required a lesser showing of materiality to establish a Brady violation. A sentence will be reversed when the cumulative impact of the evidence may well have been material to the jury's sentencing decision. Let's see. Vacating Cohn's sentence because the cumulative impact of the missing witness statements, police teletypes, and interview notes regarding Cohn's drug use may well have been material to the jury's sentencing deliberations, even though they were not material to the insanity defense in the guilt-innocence phase. D. The obligation to disclose exculpatory evidence extends way beyond what the prosecutors are personally aware of and beyond four walls of a prosecutor's office. It applies to federal law enforcement officers, state lab technicians, and other state actors. Damn right it does. The prosecution's obligation to preserve and disclose exculpatory evidence does not turn on whether the prosecutor knows of the evidence. The duty of disclosure enunciated in Brady is an obligation of not just the individual prosecutor assigned to the case, but all of the government agents having a significant role in the investigation and prosecuting the offense. Thus, the prosecutor is constitutionally obligated to actively investigate and preserve potentially exculpatory evidence. A bad faith failure to collect potentially exculpatory evidence would violate the Due Process Clause. Due process requires law enforcement to gather and to collect evidence in those cases in which the police themselves, by their conduct, indicate that the evidence could form a basis for exonerating the defendant. The prosecution may not be excused from disclosing what it does not know, but could have learned. The prosecution may not delegate the job of determining what evidence must be turned over to the defense, but instead must affirmatively seek out all relevant information from everyone involved in an investigation. Explaining that it is Kyle's, this is the case they're citing, Kyle's case here, explaining that it is the prosecutor's duty to discharge the government's Brady responsibility, and therefore a prosecutor will not be excused for failing to turn over information that was known to the police. Given this obligation, it is obvious that Brady extends well beyond the four walls of a prosecutor's office. Because Brady does not require bad faith on the part of the prosecution, the state's obligation is an affirmative duty to learn of and then to disclose exculpatory evidence in the custody of other members of the prosecution team, as well as any other state actors involved in the case. Therefore, a prosecutor's Brady obligation extends to exculpatory information obtained or possessed by any federal or investigative agency with involvement in a case, including the FBI. And United States v. Zuno Ars is your case, Ninth Circuit Court, where you're going to get the quote, on their decision there, explaining that a federal prosecutor is deemed to have knowledge of and access to anything in the custody or control of any federal agency participating in the same investigation of the defendant, including state lab technicians, right? So it's all federal. It's your whole of your FBI, anybody you have acting on your behalf as the state in your investigation. Doesn't matter if you call in the FBI, marshals, whoever you called in. They are acting as an agent of the state for you to help you. They're working on your investigation. Right? Makes sense? I think it makes perfect sense. Let's see. They cite another case here that says reversing death penalty conviction for prosecution's failure to disclose forensic crime lab worksheet showing possible drugs, which could have affected the defendant's mental state, even though prosecutor had no actual knowledge of the worksheet. Okay, so they're saying here, even if the prosecutor had no idea about it, doesn't matter. Somebody's death penalty conviction was reversed because the prosecution failed to disclose the forensic crime lab worksheet, even though the prosecutor's office, they didn't even know about it. They had no knowledge of the worksheet. Well, it doesn't matter. You should have known about it. It's your job to know about it. It's your job to collect everything. It's your case. They cite a bunch of stuff here. Bureau of Alcohol, Tobacco, Drug Enforcement. Yeah, DEA, all this bullshit. These are all other case decisions here. Let's see. United States v. Wood. The Internal Revenue Service. United States v. Bryan. Ninth Circuit Court. Prosecutor will be deemed to have knowledge of and access to anything in the possession, custody, or control of any federal agency participating in the same investigation of the defendant. Probation departments. United States v. Alvarez, crime labs. Okay. Reversing death penalty conviction for prosecution's failure to disclose forensic crime lab worksheets showing positive. Did they cite that twice? It's happening here. They cite the same thing twice. I think they did. Let's see. E. Idaho criminal rule requires the timely disclosure of exculpatory evidence. In addition to a prosecutor's Brady obligations, Idaho Criminal Rule 16A requires the prosecution to disclose as soon as practicable. Any material or information which tends to negate the guilt of the accused as to the offense charged or reduce the punishment therefore. These obligations extend to any information and material in the possession or control of members of the prosecuting attorney's staff and any others who have participated in the investigation or evaluation of the case. ICR 16 disclosure requirements apply even if prosecutors do not personally know of exculpatory and mitigating information. State v. Gardner, holding that a prosecutor violated Brady and ICR even though he was personally unaware of an exculpatory witness statement made to the police. Therefore, ICR 16 charges Idaho prosecutors with an affirmative duty to seek out and obtain all exculpatory and mitigating evidence and disclose it to the defendant in a timely manner. Let me pause here, take a break, come back over to chat. How's everybody doing? We're on page 12 of 30. I need to take a quick little break and take a little sip of my drink and come and say hi to chat. How you guys doing? Hopefully my audio is good because I can't see my chat. And I know Eddie would have been like telling me, hey, your mic's cutting in and out. But then again, I know you guys just like to talk to each other in chat, and maybe you don't even hear my mic cutting up. Puppies for peace. Yes, I'm live, honey. I'm just in another window reading, so I can't see my chat when I'm in another window reading. Sorry. Mary Holt, hello, honey. How are you? Buddy Murphy, hello. Yeah, sorry. When I'm reading, I'm in another window. I can't see my chat. All right. I just need to take a quick little break, get a drink, We're like, I'd say, what, page 12 going on to page 13? All right, not too bad. Not too bad. Yeah, I know. Yeah. Typically unique. Hello, how are you? Appreciate you. Yeah, this is the 30 new pages. Yeah, Young Black Economist. You got it. Mm hmm. This is the one. Remember, I pulled it up last night and I said, oh, hell no, this is 30 pages and it's 11:30 at night. I'm not reading this tonight. So, yeah, guys, I'm going to take a literally 2-second break here, 2 minutes. Don't dip out. You know, grab a drink, grab a snack. I'll be right back. We'll continue reading, but I have to use the restroom and grab myself a drink, okay? I appreciate it. Don't go anywhere. See if I can find some damn elevator music for you, huh? What do we got? Can you guys even hear music? Let me know if it's playing because it shows it's playing on my end, but I don't know if you can hear it because the way I have everything set up. B Smalls, how you doing? Can you guys even hear that music or no? You do hear a bass beat? All right, I'll be right back. All right. I think I'm back, and I think I shut the music off. Hopefully I did that right. Let me get back over to chat. All right. Thanks. Thanks for sticking around. Appreciate you. Looks like everybody is still here too. Wow. Awesome. Thanks, guys. Appreciate you. Trying to get some better beats for you. You got, oh, there was a little cowbell in that one. All right. Cool. Put you back on hold, Kane. Yeah, you like the music? So, fun fact, quick little fun fact. Even though I can't see Rollo in my chat here on the computer for Restream, I can see Rollo in my chat from my phone. What's up, Rollo? How weird. I can't see him in this chat on my computer screen, but I can see Rollo over here on my phone. Isn't that weird? So anyways, all right, let's get back to reading this. All right, let's see. Who do we have here? D. Smalls, hello. How you doing? Kaibo. You like the music? Detective Mowry. Fist bumping, huh? Were they cranking that at MPD? Is everybody listening? All right. Enough of the jokes. No, he's not banned. Puppies, that's the thing. He's not banned because I can see him in my chat on my phone. No problem. So it's got to be something with Restream because he's definitely not banned. I'm looking at him in my chat. Anyways, let's get back to reading this. I'm going into another window to read. I cannot see chat. All right. F. The Idaho rules of professional conduct require the timely disclosure of exculpatory evidence. And it cites here Idaho rules of professional conduct, American Bar, Model Rules of Professional Conduct further recognize prosecutors' ethical duty to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense, and, in connection with sentencing, disclose to the defense and the tribunal all unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved of his responsibility by a protective order of the tribunal, meaning when the prosecutor is removed from the case by the court. The ABA criminal discovery standards further reflect a prosecutor's well-settled discovery obligations and admonish the prosecution to turn over any and all information within their control that would 1. Tend to negate the guilt of the defendant, 2. Tend to reduce the punishment of the defendant, or 3. Any material which may be used for impeachment. Furthermore, the prosecution must disclose to the defense when they are aware of information, but do not have evidence verifying the information. So even if you don't have the evidence to verify the information, it doesn't matter. You still need to just make the defense aware you have this new information and you have not been able to verify it yet. Okay? Furthermore, the prosecution must disclose to the defense when they are aware of the information, but do not have evidence verifying the information, when it would be discoverable if it were in their possession. Prosecution has turned over mountains of unorganized, electronically stored data that defense counsel cannot possibly review prior to trial. When exculpatory material is contained in voluminous amounts of electronically stored records, the state violates its Brady obligations by doing nothing more than turning it over unorganized on a drive. In United States v. Saylor, 2010, U.S. District Court, Lexus 77617, 19 through 23, California, August 2010. The court ordered the prosecution to identify Rule 16 Brady Giglio documents contained in a voluminous discovery production as a matter of case management and fairness, the court noted. In light of the above, and to return to the real problem here, it bears repetition to emphasize that the ultimate issue is whether there is disclosure in the letter and spirit of Brady Giglio simply by turning over a mountain of everything acquired over a half a decade and telling defense counsel nothing about where exculpatory or impeaching information can be found. Again, the government cannot meet its Brady obligations by providing the defendant with access to 600,000 documents and then claiming she should have been able to find the exculpatory information in the haystack. United States v. Hija, or, as the undersigned put it in the initial order, at some point long since passed in this case, a duty to disclose may be unfulfilled by disclosing too much. At some point, disclosure, in order to be meaningful, requires identification as well. Concluding that the government must identify Brady materials in voluminous electronic records, that there is no authority for a conclusion to the contrary, and that it would be an evisceration of constitutional rights to shift the burden to the defense to review records and identify Brady materials. United States v. Cutting, ordering that the government identify all exculpatory and impeachment materials in already produced copies of electronic records because of the voluminous nature of the records and the government's production in formats that seriously impede defendants' ability to search the ESI. Without more, the United States does not comply with the requirement of Brady by merely including all known Brady material within the 4 million plus pages of discovery. So they're citing all these different cases here where things the court has already acknowledged, or this is what you need to do. No ifs, ands, or buts about it. The court concludes that the government's blanket provision here of 142 disks, including disks unrelated to this action, does not discharge its Brady Giglio obligations. In the context of vast electronic records, even the circuit courts that have adopted the most narrow approach to a prosecutor's Brady obligations have held that the government must do more than simply produce the contents of these devices. We have another one here where an affidavit in part was vacated on other grounds. The defendant challenged the government's open file disclosure of several 100 million pages of discovery in an electronic file. However, the Fifth Circuit Court held that this voluminous discovery did not violate Brady obligations because, 1, the government provided copies of the electronic files to the defense. 2, the electronic file was searchable. 3, the government produced an index of hot documents indicating the documents that were important to its case, as well as to documents that include potentially exculpatory evidence. And 4, the government had created a number of other databases to assist the defense's review of the evidence. As such, in the context of voluminous electronic data, this standard requires that the government go beyond merely providing a defendant with the open file. The state has taken none of the steps beyond mere production in this case. The electronic file is not searchable. Defense counsel must locate and click into each and every separate document, of which there are many thousands, to find its contents. The state has not produced an index of documents that it will rely on in its case. To the contrary, the expert disclosure deadline has come and gone without the state identifying its experts' conclusions and which documents they will be using to support the conclusions. The state has not provided an index of Brady material, including exculpatory and impeachment information, nor an index of documents that are potentially relevant to the defense's case. Indeed, the state has not provided anything to assist in the defense's review, despite the knowledge that it would be impossible, even through the exercise of due diligence, to identify exculpatory or impeachment evidence within the hundreds of millions of pages, tens of thousands of photos, and thousands of hours of videotape and audio recordings. Under the more exacting standards adopted by other courts, it is even more plainly apparent that the state's approach to its Brady obligations runs afoul of Mr. Kohberger's due process rights. For example, The District of Columbia has rejected the Fifth Circuit standard as too lenient, thereby directing the government to identify exculpatory information within its voluminous production. We have another case here, United States v. Sailor Supra, directing the government to create an index of exculpatory and impeachment information for the 600,000 pages of discovery that had been disclosed to the defense. Another case here, court says open file discovery does not relieve the government of its Brady obligations. The government cannot meet its Brady obligations by providing Mrs. Hija with access to 600,000 documents and then claiming that she should have been able to find the exculpatory information in the haystack. Example, the state has not timely produced indexed or identifiable portions of contents relating to the 67 electronic devices and warrant returns it intends to rely on. The above problem is exemplified, though certainly not limited to, the 67 electronic devices and other digital data and search warrant returns the state has turned over. Since the state has not provided specific reports or indexes of materials it intends to use from those devices, digital data, and search warrant returns, the defense must guess which form electronic reading software is utilized. Oh, okay. The defense must guess which form electronic reading software is utilized. Okay. For most devices, no specific report has been produced. For some devices, Axiom is used. We know that's for the body cams. And some for Cellbrite. We know what that one is. The software produces different results for the same device. So every single one of these devices has some kind of electronic reading software that's been utilized. Most devices, no specific report has even been produced. For some devices, Axiom is used. Some of them it's Cellbrite. And the software is producing different results for the same device, right? The software is producing different results. All of this for every device. Minga. Each device results in an enormous volume of information to sift through. A single cell phone often produces more than 10,000 pages of material. This is because modern electronic devices, including cell phones, have the capacity to store vast amounts of highly personal information. Yes, we know. Riley v. California. Prior to the digital age, people did not typically carry a cache of sensitive personal information with them as they went about their day. Now it is the person who is not carrying a cell phone with all that it contains who is the exception. Not only can these devices store immense amounts of information, but they also generate records that would otherwise never exist. A phone not only contains in digital form many sensitive records previously found in the home, it also contains a broad array of private information never found in a home in any form unless the phone is in the home. And then they go through all this here. Get down here. As such, the contents of all the 67 electronic devices, digital data, and search warrant returns seized in this case contain enough information to paint a portrait of the daily lives of Mr. Kohberger, the victims, witnesses, alternate suspects, and people close to the victims. Let's read that again. As such, the contents of all the 67 electronic devices, digital data, and search warrant returns seized in this case contain enough information to paint a portrait of the daily lives of Mr. Kohberger, the victims, witnesses, alternate suspects, and people close to the victims. So, interesting. They'll be able to paint a portrait of the daily lives of not only Mr. Kohberger, but the victims, the witnesses, and the alternate suspects. Given that the state's case is almost entirely circumstantial, patterns of evidence that emerge out of these devices may be key to the jury's consideration of guilt or innocence. Look at that, huh? given that the state's case is almost entirely circumstantial. Courts often describe evidence regarding potential alternative perpetrators as classic Brady material. New evidence suggesting an alternate perpetrator is classic Brady material. Williams v. Ryan. United States v. Jernigan. Withholding knowledge of a second suspect conflicts with the Supreme Court's directive that the criminal trial, as distinct from the prosecutor's private deliberations, be preserved as the chosen forum for ascertaining the truth about criminal accusations. And then we have Boyette versus Lefebvre, describing such evidence as classic Brady material. Regardless of the state's ultimate conclusions about whom to prosecute, withholding knowledge of a second suspect conflicts with the Supreme Court's directive that the criminal trial, as distinct from the prosecutor's private deliberations, be preserved as the chosen forum for ascertaining the truth about criminal accusations. Countless cases have been overturned due to prosecutors' failure to timely produce evidence that could have helped the defense identify a potential alternative perpetrator. Finding that prosecutors violated due process rights under Brady by failing to disclose the complainant's statement that it was possible he had misplaced a stolen ring. Okay. Then they cite another case here. They're talking about Comstock v. Humphreys, something Jerrigan. Finding that prosecutors violated Brady obligations by failing to disclose to bank robbery defendant fact that other nearby banks had been robbed after her arrest and that a woman had been detained with uncannily similar physical description. Another one here, Trammell v. McCoon, holding that despite witness identification of defendant, prosecutors violated Brady by failing to disclose to the defense evidence of a potential alternate perpetrator with a similar appearance. Finding a Brady violation in a second-degree murder case due to the state's withholding a police report that corroborated the defendant's version of events and supplied a motive for a different person to commit the offense. Sounds like what we have here. State withholding a police report that corroborated the defendant's version of events and supplied a motive for a different person who committed the offense. Harrington v. State, finding that the prosecution violated Brady by failing to disclose police reports identifying an alternative suspect. So it sounds like here, countless other cases have been overturned because you failed to disclose the information and the evidence relating to an alternative suspect or perpetrator. Because many of the devices belong to the witnesses, the victims, and to people who knew the victims, including potential alternate perpetrators. So notice, it's not the defense here claiming that this is some random Joe Blow schmo out of the public, right? Many of the devices belong to witnesses, victims, people who knew the victims, including sounds to me like what they're saying here is the potential alternate perpetrators isn't going to be some Joe Blow schmo lone perpetrator out in the wilderness in the wild. Sounds like what they're getting at here is these potential alternate perpetrators are going to be much closer. Yeah, since they're only talking about witnesses, victims, and that would include potential alternate perpetrators. They're only talking about witnesses, victims, people who knew the victims, and that would include potential alternate perpetrators. Defense counsel is plainly obligated to review them. Then we have United States v. Chronic. The Chronic. United States v. Chronic, explaining that where defense counsel never subjected the prosecution's case to meaningful adversarial testing, then there has been a denial of the Sixth Amendment right that makes the adversary process itself presumptively unreasonable. So far be Dretke, Fifth Circuit Court, an actual failure to investigate cannot be excused by a hypothetical decision not to use its known results. Additionally, many of the devices in warrant returns belong to Mr. Kohberger. These devices in warrant returns will paint a comprehensive picture of his life and therefore are likely to be key to the mitigation presentation at the sentencing phase. So they're going to say, yeah, see, he was a normal dude, lived a normal life, worked his ass off, tried really hard, was a runner, right? I mean, sounds to me like what the defenses play. They want to paint a portrait, a comprehensive picture of his life using his devices, yeah? But the defense cannot reasonably make effective use of voluminous electronic records because the state has not provided them in a detailed or indexed manner. Reviewing and understanding all the records from these devices, digital data, and search warrant returns alone would require 3 years, even if defense counsel did not look at any of the other discovery. And we have a footnote here. All right, footnote number 3. Of course, there is significant additional discovery which is likely to contain exculpatory evidence relating to alternative perpetrators. For example, the defense had to fight for the several thousand tips collected by law enforcement tip lines. Though they were in the state's possession the entire time, the state did not turn them over until more than a year after the case began. The defense has no way of knowing whether the state intends to rely on or introduce any evidence from those tip lines, and has never received a log of Brady Giglio evidence that the state has identified in these records. Because there is no log, an exact number is unknown, but the number of tips is more than 45,000. By the way, tips continue to be reported. Interesting. Worse yet, the state apparently intends to rely on this evidence to establish guilt through 3 different experts, but has not identified what opinions these experts have drawn from the evidence, nor which parts of the voluminous data they are relying on. The state has created a situation where the defense is completely in the dark and cannot mount even a limited investigation into rebutting their experts' testimony, including by identifying impeachment evidence or evidence that contradicts their experts' opinions. Rather than cure this defect, when court told the state that its job was not done with expert disclosures, she's saying here, rather than cure this defect, instead the court told the state its job was not done with its expert disclosures. The state submitted expert rebuttal disclosures that blamed the defense for its inability to properly disclose expert opinions related to electronics, digital data, and search warrant returns. Fucking, they're still getting tips. Oh my God. And probably still ignoring them too. The state's failure to timely disclose this evidence in a meaningful way has prevented Mr. Kohberger from developing a full defense to the allegations in this case. As a result, the defense will not have the ability to identify the critical pieces of evidence or conduct necessary follow-up investigation on those pieces the state intends to rely on in the merits phase. The failure of the state to identify important documents in the massive electronic data dump, including exculpatory documents, will hamper Mr. Kohberger's ability to meaningfully contest the state's theory. Moreover, the state's failure to identify exculpatory documents relating to the sentencing phase will prevent a capital jury from receiving a complete picture of the life of Mr. Kohberger supported by electronically generated records. Riley describes the distinct characteristics of modern cell phones that make them indispensable in an investigation. Therefore, by dumping the contents of 67 electronic devices, digital data, and search warrant returns on defense counsel without identifying the pertinent information within them, The state has violated Mr. Koberger's due process right and his right to effective assistance of counsel at both the merits phase and at a capital sentencing proceeding, as well as his statutory rights under ICR 16. Reviewing the discovery is only the beginning of defense counsel's obligations. The defense must have time and opportunity to conduct independent investigation of the state's evidence. When the prosecution seeks the death penalty, defense counsel must independently investigate all evidence, whether testimonial, forensic, or otherwise, purporting to inculpate the client. So, when the state wants to seek the death penalty against you, your defense attorney, whether they're private, assigned to you, you're given to them, you get one assigned to you because you're poor, doesn't matter. They must independently investigate all evidence, whether it's testimonial, forensic, or otherwise purporting to inculpate you. All evidence that the state is using to say you committed the crime, your defense attorney must independently investigate it. And in order for them to do that, the prosecutor needs to turn over discovery in a timely, organized manner. Or else your defense attorney isn't going to be able to fucking help you. So it says, see American Association Guideline, American Bar, blah, blah, blah. Yes, yes, yes. In recognizing the large number of individuals sentenced to death who were later exonerated because they were innocent. Let's look at this right here. Setting forth the expectations and obligations of defense counsel in capital cases uses over 178 pages of guidelines and commentary. In recognizing the large number of individuals sentenced to death who were later exonerated because they were innocent, 110 of them when the American Bar Association guidelines were written, though the number now stands at more than 195, it underscores the importance of defense counsel's duty to take seriously the possibility of the client's innocence, to scrutinize carefully the quality of the state's case, and to investigate and reinvestigate all possible defenses. Thus, a meaningful ability to review discovery and the state's case is essential to the right to a fair trial and effective assistance of counsel in a capital case. This is a case where the facts are in great dispute. Mr. Koberger asserts his innocence. There is no confession. There is no video or audio of the crime. There is no weapon. There is only trace evidence on a movable object, a knife sheath. Well, no shit. How long? Yeah, there you go. Beep, beep. Isn't that what we've all been saying? Beep, beep. Trace evidence on a movable object. Meanwhile, the back of the sheath was swabbed. And mixed sample of blood. By the way, not Koberger's blood. So they want you to believe the skin cells on the sheath are more important than the fucking blood on the sheath that doesn't match the skin cells. The skin cells in the blood in the sheath don't match. Okay? There is only trace evidence on a movable object, a knife sheath. Having full knowledge of the state's expert opinions and the documents they will rely on will provide leads for further investigation to uncover exculpatory evidence or to impeach prosecution witnesses. In addition to a complete investigation of every piece of the state's case, counsel is responsible for identifying and considering all legal claims potentially available, even if those claims have consistently lost in that jurisdiction. Meaning, no matter what, even if we're going to lose, it doesn't matter. We're going to say it anyway. We're going to get it on the record. We're going to make the claim anyway, even if we think you'll shoot us down. Counsel should object to anything that appears unfair or unjust, even if it involves challenging well-accepted practices. Agreed. This is necessary because counsel in a capital case has a duty to preserve any and all conceivable errors for each stage of appellate and post-conviction review. As the non-preservation of an issue at the trial stage may result in the defendant's execution, even if reversible error occurred. And then it cites a case here, explaining a case in which, from a joint capital trial, one co-defendant was eventually executed because his counsel failed to object to women being excluded from the jury, while the other co-defendant's case was reversed, and he is now serving life in prison because his attorneys preserved the issue. In a case as complex as this one, the state's failure to direct the defense to evidence it will rely on in accordance with the court schedule is highly prejudicial. It will undoubtedly impact the defense's ability to meet the evidence at trial, develop a comprehensive defense strategy, adequately respond to each aspect of the state's case, and complete all pretrial litigation about admissibility of evidence. Even assuming the state discloses detailed expert disclosures and an index of hot documents tomorrow, counsel will need the remaining months before trial to conduct independent investigation into the evidence and witnesses, identify evidence that contradicts the state's theories, and incorporate all of the new information into the defense's case. Liga v. Portuando, finding that the state suppressed exculpatory evidence by identifying an eyewitness days before trial, such that the attorney could not reasonably be expected to suspend other trial preparation to interview the witness, and thereby constituting a failure to make sufficient disclosure in sufficient time to afford the defense an opportunity for use. It will not be possible to do this to the extent required in a death penalty case, in addition to identifying and preserving all of the related legal claims that could stem from the evidence. Thus, as discussed below, because heightened reliability standards cannot possibly be met in this time frame, the court must preclude the death penalty. This is a capital case, and heightened due process applies. Supreme Court has been clear that the death penalty must be reserved for only those few offenders deemed extraordinarily culpable and therefore uniquely deserving of death. The average murderer is insufficiently culpable to justify the most extreme sanction available to the state. While every murder is appalling, only the most extreme qualify for the death penalty. A case is not capital just because it is the worst murder a community has ever seen. Nor is it capital because it technically checks the boxes of the necessary aggregating factors under a capital sentencing statute. A case may only appropriately be capital, in the words of the United States Supreme Court, when it falls into a very narrow category of the most serious crimes and involves a defendant whose extreme culpability makes them the most deserving of execution in the entire country. Yeah, Roper courts, Roper v. Simmons, right? And then Kennedy versus Louisiana. Yeah. Explaining that the death penalty must be limited to those offenders whose extreme culpability makes them most deserving of execution. Heightened constitutional obligations apply in death penalty cases because a life or death sentencing decision is qualitatively different from sentencing decisions involved in any other kind of case, Woodson v. North Carolina. The nature, quality, and gravity of death cases makes the defense of capital cases fundamentally unlike any other type of legal endeavor, Sawyer v. Whitley. As a result, death penalty trials require especially stringent due process from both the judge and the attorneys and may not be treated as standard criminal cases, Gardner v. Florida. See also Simmons v. South Carolina, Lankford v. Idaho. Courts must go to extraordinary measures to ensure that a death penalty trial is fair, Caldwell v. Mississippi. So long as Mr. Kohberger's death is a possible result of this case, the state of Idaho and this court must go to extraordinary measures to protect his constitutional rights. Mr. Kohberger has been prejudiced by the state's failure to fulfill its disclosure obligations, and judicial remedy is required. Because the state has failed to satisfy its disclosure obligations in a manner that would enable Mr. Koberger to further investigate and incorporate exculpatory evidence into his defense for an August 2025 trial, Mr. Koberger will be deprived of a fair trial and the right to effective assistance of counsel if the court does not remedy the situation. The court has wide discretion to remedy discovery violations as appropriate under the circumstances. ICR 16K. See also the American Bar Standards of Criminal Discovery, right here. Generally, when the state has failed to timely produce evidence in violation of the Constitution, the trial court must choose between barring further prosecution or suppressing the state's most probative evidence. In past cases, courts have entirely dismissed indictments based on discovery violations to protect the defendant's constitutional rights, to sanction the government for misconduct, and to deter future Brady abuses. Let's read that again. In past cases, courts have entirely dismissed indictments based on discovery violations to protect the defendant's constitutional rights, to sanction the government for misconduct, and to deter future Brady abuses. United States v. Diabate, dismissing indictment because prosecution failed to follow two local rules of discovery requiring them to: 1, inform all law enforcement agencies of their discovery obligations, and 2, require all agents involved in the case to maintain contemporaneous notes. States v. Dollar, dismissing the case with prejudice after government flagrantly breached its obligation under Brady to produce exculpatory and impeachment materials in a timely manner. State v. Martinez, affirming trial court's finding that the defendant was prejudiced because the late discovery compromised defense counsel's ability to adequately prepare for trial. State v. Harris, affirming trial judge's dismissal of a case when exculpatory material was withheld. Mr. Koberger is not requesting dismissal of the indictment for these violations, at least at this point. Because 5 months remain before trial, the defense believes there are remedies that this court can order, short of dismissing the case, that will likely remedy a significant amount of the prejudice. Preclude experts and testimony not properly and timely disclosed by the state. That's one way to do it. Here's one of the remedies. Mr. Koberger requests that the state be prohibited from introducing experts' testimony and underlying evidence that has not been properly detailed in an expert disclosure for which the deadline was January 9th, 2025. Those specifics are detailed in the accompanying motion in limine. Second, here's another remedy, Your Honor. Require the state to provide a hot documents index of information it intends to rely on, as well as Brady Giglio evidence, in accordance with the minimum standards for voluminous electronic discovery. Given the compounding prejudice of late disclosure with the extreme amount of discovery has been provided in a format that does not meet the minimum standards that courts have considered, see Section 2 Supra, Mr. Koberger respectfully requests that this court order the state to provide within 2 weeks or the soonest this court deems reasonable. 1, a detailed index of the discovery and evidence they intend to rely on at either the merits phase or in sentencing. And 2, a detailed index of Brady Giglio documents and evidence, including potentially exculpatory or impeachment information. Given the amount of data, the government cannot meet its Brady obligations by providing Mr. Koberger with access to more than 68 terabytes of data and then claiming he should have been able to find the exculpatory information in the haystack. Oh, shit. All they did was take this court case here and replace it with Koberger. Both of these indexes should include, oh, we have a footnote here. Let me get the footnote first. Mr. Kohberger reserves the right to request dismissal if and when the circumstances warrant it. So he's reserving his right to request dismissal if and when the circumstances warrant it. The state's current method of, so people out there saying he's trying to get a plea, he's going to take a plea deal. No, he isn't. This motherfucker's reserving his right to request this shit be dismissed if it isn't remedied correctly by the court. Both of these indexes should include location of the document in a way that makes it easily identifiable by the defense. U.S. v. Saylor Supra, ordering government to identify Brady information within electronic discovery already produced. As discussed above, evidence pointing to a possible alternative perpetrator or anything refuting the state's theory is bedrock Brady evidence and should be included. Moreover, if this proceeds as a death penalty case, Brady material includes any evidence that would tend to mitigate punishment. Examples of this evidence in a capital case include evidence that a capital defendant was a devoted and loving family member, that he experienced trauma, neglect, isolation, or ostracization as a child, young adult, or adult, that he excelled in his education, that he experienced blows to the head or other potential brain injuries, that he experienced depression, anxiety, or other symptoms of mental illness, that his symptoms began before he was charged with capital murder, and or that he is susceptible to pressure, manipulation, and or exploitation. Interesting. Another remedy, 3, preclude the death penalty as a potential sentencing option. Courts have also precluded the prosecution from seeking the death penalty in would-be capital cases when the prosecution fails to satisfy their pretrial discovery obligations. As the First Circuit Court has noted, dismissal of the notice to seek death is not as extreme as dismissal of an indictment. The government may still seek a conviction and the serious penalty of life imprisonment. This less extreme remedy is appropriate even in situations when the violations would not amount to a sanction in a non-capital felony case. Quoting here, we do believe that in a capital case, when the stakes are so high, a smaller quantum of prejudice may justify a sanction than in a regular murder case. And as discussed above, striking the notice is not quite as serious as dismissing the indictment altogether, and so perhaps still less prejudice is required. Another Idaho trial court recently concluded that precluding the death penalty was the only way to cure the prejudice of disclosure violations by the state. In Idaho v. Lori Vallow Daybell, the state had bait stamped and previously provided more than 80,000 documents in discovery. However, the prosecution failed to turn over approximately 5,000 pages of discovery and 30 hours of audio files until a month before trial. The court ruled from the bench and signed the order. Interesting. This is notably many, many multitudes less than the 68 terabytes of discovery turned over in this case. Though the prosecution filed the discovery only one day after the deadline set by the court, the defense argued that there was insufficient time for counsel to review the significant discovery in a meaningful manner and complete any necessary follow-up prior to the trial date 1 month later. The court agreed and found that dismissal of the death penalty was appropriate in order to mitigate the prejudice. The court specifically found, so here we go, Judge grants Lori Vallow's motion to dismiss death penalty. The court specifically found that the state had acted in good faith and attempted to disclose all discovery, and that the remedy was not in any way intended to be a sanction for bad faith or misconduct by prosecutors. However, the court specifically noted that death is different, and that heightened standards of reliability and unique state safeguards must apply in a death penalty case, and therefore striking the death penalty was the only appropriate remedy. The court has commented in other proceedings related to Mr. Kohberger's trial setting and motions about discovery and expert opinions that Lori Vallo's case is distinguishable because she had not waived her speedy trial rights. However, in this case, it is the court that is repeatedly telling all counsel and Mr. Kohberger that the trial date is set in stone and everyone must be ready to proceed by July 30th, 2025. In another case, a federal district court precluded the government from seeking the death penalty for two defendants after the prosecution failed to turn over some of the statements made by a witness for approximately 1 year after the defendants had been arrested. This case here, the judge found that the defendant had been prejudiced because the prosecutor's repeated delays and failures to provide timely and full disclosure hindered the defense's ability to investigate the crime. Due to the fact that discovery was not disclosed in a timely manner, the prosecutor's conduct easily passed the threshold to bar the government from seeking the death penalty. And then, preclusion of the death penalty was the only viable remedy that protects the dignity of the process and the rights of a death penalty eligible defendant. In yet another case, the court declared a mistrial and precluded the death penalty after discovering that the state did not turn over all the noting officers. The judge specifically noted that the prosecution was not and had not acted willfully or in bad. Unintentional failure to comply with their discovery obligations had deprived the defendant of his rights to due process, fair trial, and effective assistance of counsel. While a mistrial alone may have cured the violation, the court ordered preclusion of the death penalty in the retrial as an additional sanction. In a case like this one, where more than 68 terabytes of discovery has been produced, the failure to direct the defense and discovery, the failure to direct the defense to evidence and discovery it will use in support of expert conclusions as required by the disclosure rules will result in the same prejudice as if it was not turned over at all. Several other judges have struck the death penalty as a sentencing option in response to disclosure violations as well. And then it cites these states, sanction for discovery violations by the state, ordering the case to proceed as a regular felony proceeding after the prosecution. United States v. Gomez, precluding the death penalty where the prosecution failed to clarify the nature of a meeting with the Department of Justice regarding this case, coupled with the prosecution's flagrant and admitted disregard of the court's discovery deadline. We're almost done. We're almost done, guys. Almost there. My eyes are going to bleed. Mr. Kohberger has repeatedly brought forth facts that demonstrate serious prejudice to his due process rights. He has repeatedly raised the issue of the chaotic and disordered production of discovery. He has repeatedly compelled discovery. Regardless of whether it was purposeful or inadvertent, the prosecution has shirked its responsibility to fulfill its constitutional obligations to provide timely disclosure to the defense. As a result, the defense's ability to investigate has been seriously impeded. The defense's ability to investigate has been seriously impeded. Regardless of whether the failure to organize the voluminous discovery into a searchable and usable form, identify potential exculpatory evidence, and provide minimally adequate expert disclosures on the timeline set by this court is intentional or merely the result of inattention, the prejudice is the same. Indeed, other courts have precluded the death penalty on far less, and bad faith is not the standard for applicability for sanctions. Let's see, looks like an appellate court decision here. Affirming dismissal of indictment and noting that governmental misconduct need not be evil or dishonest in nature. Simple mismanagement is sufficient. We had another one here, precluding the death penalty despite the clear absence of willful conduct or bad faith. State v. Montgomery, precluding death penalty based on considerations of due process for the capital defendant without addressing good faith or bad faith on part of the prosecution, noting that, quote, everyone involved in this case wishes the violation never happened, Jesus. Striking the death penalty is the only remedy that begins to adequately address the prejudice to Mr. Kohberger. Even with the hot documents list and detailed expert disclosures, the minimum necessary for this case to proceed to trial, counsel is at a massive disadvantage given the limited resources as compared to the state and the fact that only 5 months remain before trial. The tactical advantage that the state has gained because the defense complied with the court's disclosure deadline cannot be remedied after this fact. So because the defense complied with their expert disclosure deadline and the state didn't, right? What's happening here? Well, wouldn't you know? What happened? Well, the state got to see all of the expert stuff from the defense first. So they got to see all of the arguments and everything from the defense experts first before the state had to disclose any of their stuff. Isn't that interesting? So basically, the state got to take a look at the defense's case. They got to take a peek at the case, even though the defense doesn't get the same courtesy. Interesting. Even with a hot documents list and detailed expert disclosures, the minimum necessary for this case to proceed to trial, counsel is at a massive disadvantage given the limited resources as compared to the state and the fact that only 5 months remain before trial. Tactical advantage that the state has gained because the defense complied with the court's disclosure deadline cannot be remedied after the fact. Though counsel could proceed to a non-capital trial by making strategic decisions about what to follow up on in the limited time frame, counsel will not have time to complete the type of investigation that would be necessary to meet the required heightened reliability standard in death penalty cases in light of the late disclosures and mountains of discovery. Precluding the death penalty is therefore necessary to enforce Mr. Kohberger's constitutional rights. This remedy will also reduce the significant risk of seating a conviction-prone jury that does not hold the prosecution to their burden of proof. A fact that would exacerbate the state's already gained strategic and resource advantages. Though a risk will remain that the extensive and prejudicial pretrial publicity will negatively impact the fairness and accuracy of the jury's fact-finding, this risk will be mitigated when it is not compounded by the process of death qualification, a process that skews the jury towards conviction and death during voir dire before a single piece of evidence has been presented. Let's go read this footnote. Mr. Kohberger hereby incorporates all arguments and authorities contained in his motion to prevent death qualification of the jury. Oh, okay, cool. Oh my goodness gracious, we did it. 30 pages, friends. Wow. Let me come back over to chat. My eyeballs feel like they're going to burn out of my face. Let me rub my eyes for a second, friends. Let me rub my eyes. My goodness gracious. What a nightmare this is, huh? Yeah. Exactly, Heather. They've stolen your wallet, but they're also hanging around all day to help you find it. Yep. How you guys doing in chat? Sorry, I was in another window reading. I'm so very, very, very sorry. If you're trying to get my attention in chat, if I'm reading, I'm in another window. I can't even see you. Can't even see your comments. Sorry, friends. Let me get over here. 168 people watching. Well, hello. Hit the like. Hit the thumbs up. Hit the thumbs down. Do something. All right. So, now, what do you guys think about that, huh? All of the data for the alternative suspects. They're going to be able to give a whole life story of who they believe the alternative suspects are. We're going to be able to present a life story, huh? That's interesting. Susie High School, how you doing? Welcome on in. Or hello if you've been here. Yeah. I don't know, guys. All I know is my eyeballs are bleeding out of my head. It's 11:17 at night, yet again. Almost 11:30. I have a whole other job, a whole other life, and yeah, I'm beat. So, but I did want to read through this because we didn't get to it last night. 30 pages today. So, um, yeah, Twiz, hang on. I'll bring it up for you, honey. Let's do it right now. How about that, okay? Just for funsies, Twiz. Just for funsies. Let me get that for you. Although my brain's a little fried, my eyeballs are burning. Where was it? Not asking for them to dismiss. Where is that? Reserving that for later. It's in a footnote, too. Da, 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 da. You know what, Twiz? I love you, but my eyes are burning out of my head. You can find it on your own, honey. Let me go see. I'll see if there's anything new. Hang on. I don't think so, but there might be one thing earlier that came in. Something about a, whatchamacallit, modifying the contact order. Wait, what the fuck is this? Motion to seal Exhibit A to defendant's 7th motion to compel. What? What's this? Oh, something already either previously sealed or redacted. Okay. Something already previously sealed or redacted. Okay. Modify the contact order. This is somebody adding on their wife and stepkid. Don't know who that is. Yeah. No contact order. Modification of a no contact order previously filed herein, prohibiting the defendant from having any contact with the father of one of the victims, modified to include, let's see, Ann Taylor has no objection to amending the no contact order to include the wife and stepdaughter. So, I don't know who that is, but somebody has a wife and a stepdaughter they're adding here. Santa's daddy got married. Cool. Defendant's 7th motion to compel discovery. 2 pages. Comes now, Brian C. Koberger, vying through his attorney's record, Idaho criminal rule, hereby moves the court to order the state to comply with the defendant's 22nd request for discovery, 1/28/2025. Each of the requested items that are still outstanding are outlined in the attached 7th motion to compel Exhibit A, filed under seal. Okay. And that's all I'm seeing for today. Twiz. So yeah, Twiz, love you. You'll have to go back through that document and find it yourself, honey. Sorry, my eyes are bleeding. And I'm tired and I want to go to bed. So, oh, Friday's Live? Okay, well, there you go. See, everybody can go head on over to Friday's Live because I'm about to dip on out of here and go take myself to bed. But tell Friday I said hello. I have an early day tomorrow. I'm working literally a lot through the entire weekend. That's all I'm going to be doing is working, working, working. So, yeah, you guys have a great weekend and take care and be safe. And mods, I love you and thank you so much for being here. And all of you, thank you so much for being here. Thanks for hanging out. Thanks for checking in. Thanks for giving it a listen. You know, don't forget, hit the like on your way out. Yeah. Peace, love. Good night, everybody. Catch y'all somewhere else later on. Bye.